The Non-Profit Alliance of Consumer Advocates has spent years helping clients just like you handling the difficult foreclosure process and has been able to put them back on the path of financial stability. Starting with only one simple phone call, our team of specialists will begin acting on your behalf with the goal of taking you out of foreclosure through our non-profit 501c3 status and, when possible, get you paid for your damages. Today, let's delve into the solutions of a Notice of Trustees sale, commonly called an NOT. You've been in default on your property, and now you may even have received a sale date. And your lender won't help you because you have equity in your home. Like many, you have been advised to sell or refinance your property. Unfortunately, this quickly can turn into a catch-22. Because your mortgage has late payments, you don't qualify for a new home loan. And without fast, drastic changes, you stand to lose all your equity and face eviction. However, a not-for-profit legal clinic with the federal government's 501c3 credentials has been set up to solve your problem by the Non-Profit Alliance of Consumer Advocates. Once our loss mitigation alternative to foreclosure package is received by your lender, Senate Bill 900 mandates your lender to immediately cease and desist all foreclosure activity. This delay can include, but is not limited to, even a last-minute trustee sale. Nothing can be done against you until they have fully reviewed our loss mitigation package and properly responded in writing. It's the law. In summary, it would be illegal for your lender to complete a foreclosure without the proper review of our package, a package that we can submit for you today. What do we charge for our fee? To submit a file for you, we only ask for 4 bags of canned goods or non-perishable items to be voluntarily donated to the homeless. Once we have successfully obtained for you a new restructured monthly payment on your home, and if we get your lender to push back your first new modified payment by 30 to 60 days, we will then seek a voluntary tax-deductible donation from you to be made to Veterans Outreach in lieu of your first restructured skipped payment, which will help feed and house homeless and neglected U.S. veterans. What if my lender's response is a denial, or they have refused to help me or make me a sustainable and reasonable offer? If you have been turned down, your lender is in the obligation to provide you with a written explanation for the denial. That document automatically gives our loss mitigation director 30 days to find ways to overturn that decision, while the legal status quo still forbids your lender to finalize the trustee's sale. For example, if your lender states that you do not earn enough to keep your house, we look for potential omitted rental income that you may have forgotten to properly document. On the other hand, if the lender states you make $750 too much, we will look for omitted expenses that would balance out the difference. Once again, we have 30 days from the date of the written denial to appeal and request an approval. Furthermore, from the moment the lender stops the trustee's sale to review our package, as Senate Bill 900 mandates, we will immediately check your eligibility for additional backup plans, such as Family Gift of Equity Transfer Sale, allowing a relative or family member to purchase your home with your gift of equity, so they can qualify for today's best market loan terms as if they were to put a large down payment but with zero cash out of anyone's pocket. Yes, zero cash out of anyone's pocket. A private investor bridge loan to get you current on your delinquent loan with prepaid payments for 1 year, and a credit repair program to get you eligible for a Fannie Mae or Freddie Mac A-plus paper permanent loan in a year, simply by using a fraction of the equity you stand to lose if your lender forecloses on you. We can also escalate your file to have a state bar licensed foreclosure defense law firm look for any regulatory violation in your loan that may have occurred. They will inspect your file from its origination to its servicing, as well as possible faulty or illegal loan transfers from one entity to another through their recent failure to comply with Senate Bill 900 in order to seek a temporary restraining order against your lender to avoid foreclosure, allowing us to then negotiate a restructured loan as a possible settlement to avoid continued litigation. NACA law can even introduce a non-flip investor who focuses on asset retention, who may possibly agree to lease you back your home with a possible purchase option. And finally, bankruptcy protection only as a last resort. What if they foreclose on me and I lose my home? Typically, you stand to lose 100% of any equity you have built up and possibly face eviction, not to mention your ruined credit for the next 10 years. But as long as we are able to get our non-profit loss mitigation package to your lender today, any foreclosure action on their part would be a direct violation of Senate Bill 900. If this is the case, as per Civil Code 2924.12b states, if the court finds a material violation was intentional or reckless, or a result from willful misconduct by mortgage servicer, mortgagee, trustee, beneficiary, or authorized agent, the court may award the borrower the greater of treble actual damages or statutory damages of $50,000 per violation. If your lender has failed to adhere to Senate Bill 900 on our submitted non-profit loss mitigation package, we can generally document and record anywhere from 1 to 3 total violations, up to $50,000 per violation. That could add up to $150,000 in statutory damages, or 3 times your lost equity. So, if you lost $150,000 in equity, you could seek $450,000 in punitive damages through the courts. Today, the Nonprofit Alliance of Consumer Advocates has built-in relationships with state bar licensed law firms all over the country that will prosecute your lender for wrongful foreclosure on your behalf with zero cash out-of-pocket costs to demand the reversal of the trustee sale and put your house back into your name. And if for any reason you don't want your home back, or you're unable to legally get your home back into your name, the attorneys we have agreements with will prosecute your lender for lost equity plus punitive damages that can be more than 3 times the equity you've lost. Here are some examples of damages paid to homeowners for wrongful foreclosure. Alvarez versus BAC for lender's mishandling of the loan modification, awarded $200,000, which includes punitive damages. Jane McGinnis versus American Home Mortgage Servicing, $11 million award, including punitive damages. Yuba County jury awards $16,200,000 to a homeowner in a wrongful foreclosure case. See Linzer versus Century 21 Mortgage. So if you haven't contacted us yet, visit www.nacalaw.org or call 855-622-2435. That's 855-NACA-HELP.